So we'll begin the meeting. Welcome to this Legal and Planning Committee meeting. We have a number of apologies. Apologies from Councillor Gibson, Beregi, Welsh. Is there a, we don't need to do a move at leave of absence. And we'll move to the first item, which is the confirmation of the minutes. Is there a mover? Thank you, Councillor Santa. Is there a seconder? Councillor Burke. All those in favour? Thank you, that's unanimous. That will take us to the first item, current appeals and results. Is there a mover of the recommendation, which is receipt of the report? Thank you, Councillor Lamb. Is there a seconder? Councillor Santa. Is there any discussion or questions? Councillor Burke. That's item 4, that's the confirmation. And so we've moved to the 5.1, current appeals and results.
Thank you, Mayor. I have a comment. So I've received some correspondence over a period from one of our residents regarding a development in Bray Street, and I would ask a question through the chair of the director, Joseph. A couple of questions with regard to that. Sorry for the noise. In particular, obviously the property in question is in Bray Street, I believe 20 to 24, and there were significant concerns from the local community regarding opposition to the development and around bulk scale site coverage and what basically non-compliant height invasions of privacy and unsympathetic design. And I was wondering if I could have some comments around why our council staff did consent to this development in private discussions with the developer, I believe under Section 34 discussions.
So it's, just for clarification, your question is the process around coming to an agreement under Section 34?
Correct, Mayor. 20 to 24 Bray Street, North Sydney.
If I may answer that question, Mayor. That matter was heard under Section 34. If you're familiar with the application, it proposed alterations and additions to an existing building under existing use rights. So although there's some requirement to have regard to planning controls under existing use rights, it's a much more fluid environment. We did negotiate through a process which involved our external legal advisors and consultant planners for a reduction in the bulk and scale of that building, that proposal, to the point where the court was in a position to support it. So ultimately it wasn't a council decision, it was decision of the Land Environment Court. One of the things about the Section 34 process is regardless of what the parties agree on, the Commissioner also needs to be in the position to state that it is an outcome that the court would normally approve of. So it's very difficult. One of the concerns that I've had with the whole process is that the residents get to be heard of at the beginning of the process, but when the process is in its concluding phases, the residents aren't involved. It's just merely for the parties, which is typically the council and the applicant.
Thanks for that response. And yeah, that is coming back from a lot of people, that the residents don't get to see the further discussions prior to the confidential agreement being struck, and that is a problem with our state planning system. However, I think we do need to be pushing back where I get the existing use rights were appropriate in this case. But I do feel like we need to be pushing back against these types of developments further. And Mayor, I'd like to move a motion that we receive a report on this agreement in the next meeting.
What sort of a report? Report on what?
A report just detailing why we agreed to this Section 34 process, and that we didn't, I guess, require further setbacks and the like. Why we agreed to this application as it stood, and because there are significant areas of non-compliance according to residents to the LEP.
Could I suggest for maybe that you broaden what you're seeking, and that it be on the council's approach to Section 34 conciliation conferences and agreements more broadly, and the report could include your particular one as an example. But certainly I think that there, speaking slightly in support of your motion, I think that there's value for a new council to think about how the council approaches agreements through the court, and have an understanding about the policies and the approach in place. So I think that's probably encapsulated in what you've moved, which is a further report, but maybe it should be on the process and the policy around Section 34 agreements generally, with some detail about Bray Street in particular.
Thank you, Mayor. I'm happy with that. And obviously, I respect the position that our staff are in a difficult position with the planning system, but also for new councillors to better understand. I think this would be very helpful to understand these processes. So I appreciate that.
Is there any other discussion? Yep, thank you.
I agree, Councillor. It is quite a difficult position, but one of the things the Section 34 process, next stage after that, is a full-blown appeal. Now, there's no obligation for the applicant to, follow the amended plans. He might choose to have the plans he's proffered in the first place contested, which means there's a great deal of uncertainty in the process and also a great deal more expense. So they're the two issues. And finally, we don't make the rules around the way the Land Environment Court functions. That is a state government matter. And again, as I mentioned, the concerns that you've raised and are raised by residents are often raised in regards to the way that Section 34 process is managed and run by the court.
And it's certainly raised by pretty much every metropolitan council, maybe all councils in New South Wales. So if there's any other discussion, I'll put the motion. All those in favour? That's unanimous. Thank you. We'll go back to the agenda. My apologies. Are there any declarations of interest? No. That takes us to item 4.1, development applications received. Is there a mover of the receipt of that item? Councillor Burke, seconded by Councillor Santa. Is there any discussion on the item or questions? Councillor Santa?
Thank you, Mayor. Thank you, Mayor. I just have a couple of questions. In the text, it says up to a third of the application stream consists of modifications to applications. and the proportion of modifications has grown in recent years, perhaps due to the greater scrutiny placed on building certifiers and an increasing reluctance to use previous discretions. I'm just wondering if someone could really explain that to me in plain English. I honestly don't understand. I mean, I can understand the COVID aspect for the decline, but I'm just wondering if there are other factors that we need to be aware of.
Mr. Hill or Mr. Beattie?
Thank you, Councillor. It's an interesting question. The current certification system has been in place since 1998. Over that period of time, there's been much criticism about outcomes both by local authorities, consumers and the industry as a whole. One of the issues turned around the discretion that certifiers were using in determining whether a development proposal was consistent with its development consent, or indeed while works were going on site, whether or not those works were consistent with development consent. Now, it's a given fact that I would say very few development proposals are completed exactly in accordance with the approval. There's minor variations. It's what happens on construction sites. Certifiers used to, depending on who they were, take quite a great latitude in approving those through the construction certificate process and accepting changes from the DA. With the increasing scrutiny on certifiers, particularly over the last 5 years, they have chosen not to use that discretion. And so we see quite minor changes as modifications to applications that, for example, I would have accepted if I was a certifier, but we see it all the time.
Any other questions, Councillor Santa? No. Thank you, Mr. Beattie. Thank you, Councillor. Is there any further questions or discussions? No, I'll put the motion. All those in favour? That's unanimous. That takes us to variations to development standards, the third quarter reporting period. Again, is there a mover of the recommendation, which is receipt of the information? Councillor Burke, seconded by Councillor Lamb. Is there any questions or discussion? In the absence of that, I'll put the motion. All those in favour? That's unanimous. We've looked at item 5.1, current appeals and results. There is a legal matter under the confidential reports, but unless there's discussion that councillors may like to have, we could move the confidential recommendation in open session. Is there, do any councillors wish to speak about the report and the recommendation in confidential session? No. Is there a mover for the recommendation? Councillor Burke, seconded by Councillor Santa. Councillor Mutton, do you have any questions or discussion?
No, I don't, Mayor.
Anyone else? In the absence of that, I put the motion. All those in favour? Those against? That's unanimous. I should read now the recommendation, the resolution, the recommendation of the committee from the confidential. I'll just get to the point. Sorry, it's freezing on my screen. Yes, if you wouldn't mind, although I've just pulled it up. So, Council, the committee has just resolved that Council notes a Class 3 application disputing the amount of compensation that Council has been offered by Transport for New South Wales on the parcels of land that have been compulsory acquired from the Council for the upgrade of the Warringah Freeway has been lodged with the Land and Environment Court on 3rd of June 2022, and the matter is listed for directions on the 8th of July 2022, that Council notes the points of claim and revised quantum of compensation in draft that is being recommended to pursue through the Class 3 proceedings, that a further report be brought to Council at the conclusion of the directions hearing on the 8th of July, and 4, that the report be treated as confidential, remain confidential until Council determines otherwise. With that, are there any matters of urgency? No. I close the Legal and Planning Committee meeting. Thank you all for your attendance and participation.